All right, let's dive into the one thing that truly makes a contract tick: consideration. We're going to break down what it is, why it matters, and look at the key rules in sections 2D and 25 of the Indian Contract Act. So let's get right into it. So have you ever wondered what the difference is between just a simple promise you make to a friend and a promise that a court will actually enforce? What's that secret ingredient, the thing that transforms a casual "I'll do it" into a real legal obligation? Well, it all boils down to this one powerful core idea: quid pro quo. So that secret ingredient, that quid pro quo, is what the law officially calls consideration. And Section 2D of the Indian Contract Act gives us this long formal definition. But I want you to zero in on one crucial phrase: at the desire of the promisor. This is everything. It means the action, the thing being done, has to be because the person making the promise asked for it. If you miss that, you miss the whole point. At its very core, if you remember nothing else, remember this phrase: quid pro quo. It literally means something for something. This is the fundamental DNA of a contract. It has to be a two-way street. Each person has to get something and give something. Think about buying a coffee. You give your money, they give you the coffee. That's it. That's quid pro quo right there in your daily life. But it's not quite enough to just have an exchange. Like any good recipe, there are rules you got to follow to make sure your consideration is actually valid and your contract is, well, not going to fall apart. So let's look at the essential rules of this recipe. And here it is, the absolute golden rule, especially if you're studying for exams. The act, or the promise, must, and I mean must, be done at the desire of the promisor. If you just voluntarily do something nice for someone without them asking, well, that's kind, but it is not legal consideration. If the promisor didn't request it, the whole contractual chain is broken right at the very first link. Okay, rules are one thing, but how does this stuff actually play out in a real courtroom? The absolute best way to get a feel for this is to see the theory in action. So let's jump into some landmark cases that really define how we think about consideration today. This case, Durga Prasad v. Baldio, is the perfect example of our golden rule. So picture this: a guy builds a market. But here's the key: he did it because the district collector asked him to, not because some shopkeeper did. Later, one of the shopkeepers who benefited from the market promised to pay him a commission. The court said, nope, not enforceable. Why? Because the act of building the market wasn't done at the desire of the promisor, the shopkeeper. The request came from someone else entirely. Case closed. Next up, let's look at the classic English case of Curry v. Misa. This one is famous because it gave us another way to think about consideration. The big takeaway here is that consideration is a two-sided coin. It can be a benefit to one person, like getting paid, or it can be a detriment to the other, meaning they give something up or take on a burden. It's not just about what you gain. What you give up counts just as much. So right about now, you're probably thinking, okay, I get it. No consideration, no contract, simple. But the law loves a good plot twist. There are actually a few very specific, very important exceptions where a promise can be totally legally binding, even with absolutely nothing given in return. So if quid pro quo is a promise with something in return, its opposite is this term, nudum pactum. It means a naked promise. And normally, a naked promise is just that, bare. It has no legal close, no weight, no power. But, as we're about to see, there are a few special occasions where this naked promise gets to dress up and become a valid contract. And this is where Section 25 of the Act comes into play. It lays out these three big exceptions for us. You've got promises made out of natural love and affection between close relatives. Then there are promises to pay someone back for a past voluntary service. And finally, a promise to pay a debt that's so old it's legally unenforceable, or time-barred. These exist really to make sure the law is fair in situations where sticking to the strict rule would just feel wrong. But hold on, because even these exceptions have their own strict rules. Check out this case. A husband promised in writing to pay his wife maintenance, but they were constantly fighting. The court looked at it and basically said, look, just because you're married doesn't automatically mean there's natural love and affection. You actually have to prove that genuine affection exists for this exception to kick in. The relationship alone isn't enough. Okay, let's pull all that together. This is your quick revision slide, the one you want to screenshot. So, what have we learned? Consideration is quid pro quo, something for something. The general rule is nudum pactum, no consideration, no contract. The absolute golden rule from Durga Prasad is that it must be at the desire of the promisor. And the classic definition from Curry v. Massa tells us it can be a benefit or a detriment. And of course, don't forget those 3 key exceptions from Section 25. Got it? Good. And I'll leave you with a little something to think about. Imagine you promise to donate a big sum to a charity, and because of your promise, they go out and hire builders and start construction. Should you be legally forced to pay up, even though you technically didn't get anything in return? It's a fascinating question, and it really tests the limits of everything we've talked about today. Something to chew on. Thanks for tuning in.